Funding for Current Conversations is provided by University of Oklahoma President's Office, University of Oklahoma Outreach, and World Literature Today. Welcome to Current Conversations. I'm Con Davis-Undiano, and today we're going to be talking about current directions in Indigenous rights and the law. We'll be talking to Professor Lindsay Robertson, who teaches Indigenous Law at the University of Oklahoma, and he is the director at the Center for the Study of American Indian Law and Policy. He's also the founding director of the International Human Rights Law Clinic. We'll also be talking with Professor Taiawagi Helton, who is a specialist in Indian and environmental law, and he is the assistant director at the Center for the Study of American Indian Law and Policy. Okay, I've got a tough question I'm just going to throw out right from the beginning. I think most people see the United States as a progressive place. It's built dams, gone to the moon, mapped the human genome, and it's had 200 years, over 200 years, to work out relations with its indigenous people, particularly in terms of Indian rights, of indigenous rights. Could you give, what midterm grade would you give the United States at this point?
I don't think I could give a midterm grade. I think I'd have to give grades for about 8 policy eras over time. And I don't know what the cumulative grade would be in the end, but there have been some really incredible things that the United States has done, and some absolutely terrible things as well. But we're now in an era of federal policy described as the self-determination era, and every president since Nixon has articulated in one form or another support for self-determination and tribal economic self-sufficiency. So at least Congress and the executive branches since the early 1970s have been, for the most part, supportive of tribal self-determination rights.
It sounds like there would be some mixed grades, some low grades and some higher grades trending up, but okay.
Indeed.
Well, the problem with the history of federal Indian policy is that it's been somewhat schizophrenic. So you have early phases, as Ty suggested, in which the policy's been awful. This would include the removal period, which brought a lot of the southeastern tribes to Oklahoma. The allotment era at the end of the 19th century, when tribal reservations were broken up and divided, with so-called excess lands sold off to non-Indians as part of an attempt to destroy tribal political communities. But then you have other periods where the federal government's supportive of tribal self-determination, separate tribal political identity, et cetera. I mean, one thing I think that you have to say, to be fair, is that it's actually nice that we're able to talk about giving a grade to federal Indian policy, because there still is federal Indian policy, because in the United States, indigenous peoples are still recognized as separate political communities with inherent sovereign rights and powers. And that's not true in most other places where there have been colonizers and indigenous people whose lands have been taken from them. Those people have ceased to exist as separate political communities.
Well, in regard to that issue about lands being taken from them, let me ask you about a few mainly Supreme Court decisions, and I hope you'll fill in what I don't have here. Okay, 1832, Johnson versus McIntosh. Doesn't this sort of deal with lands issue? What's significant about that Supreme Court decision?
Yeah, 1823 is Johnson versus McIntosh.
Sorry.
Yeah, and then 32 will be Worcester versus Georgia. Johnson versus McIntosh was a put-together claim by a group of land speculators trying to claim title to lands in what would become the states of Indiana and Illinois, pursuant to purchases from the tribes that lived out there in the sort of last stages of the British Empire. So it's really a British law question. Were their purchases valid under British law? And what the Supreme Court decided to do with it, though, was to turn it into the foundation principle for United States tribal relations and for defining Indian rights to lands, real property rights, under U.S. law, which was a slightly different question.
Is this what they call the discovery doctrine?
Yeah, well, that's exactly it.
Yeah.
And so the method by which the court chose to decide the case against the speculators was by saying that the tribes from whom they had bought these lands didn't really have a full ownership of the land that they could sell to them, and what they did have, they couldn't sell to them. And the reason was international law at the time of the discovery of North America, according to the court, provided that upon discovery, the discovering European sovereign acquired ownership of the underlying title to all discovered lands. What the indigenous people retained was the right to occupy those lands, an occupancy right, and they could sell that, but only to the discovering sovereign. So there's a limitation on the right and on the capacity to sell.
That law, not law, but that decision just seems to create a troubling tone right from the beginning. I have this image of a European colonizer setting foot in North America and just kind of instantly, okay, it's ours. We discovered it. I mean, it's a strange, it's a creepy notion.
Yeah, if you take the Marshall trilogy together, that's Johnson versus McIntosh, Cherokee Nation versus Georgia in 1831, and then Worcester versus Georgia in 1832, you see a shift in Marshall's language, and he uses much more colonialistic style language in Johnson than he does in the later cases.
Now, 1831, that's the domestic dependent nations where John Marshall says that the relationship is that of a ward to a guardian, right?
That's right, he draws that
Indigenous
guardian ward
people
analogy.
are wards. Federal government is the guardian. Is that right?
Yeah, he was actually comparing the relationship of tribal governments with the United States government rather than individual Indians. But yes, he analogized to a guardian-ward relationship, and that provides us with the basis of what's known as the trust doctrine.
Yeah.
But Marshall expressed in later years some regret over how the language from Johnson had been used because it was so strong.
Well, I'd go even farther than that, and I have a book on this. So I'm going to have a lot of opinions on it that may or may not be right, but they're mine from years of research in this topic, and I think they're right that Marshall actually, I think we overstate the legal significance of the guardian ward language. What Marshall was trying to do in the Cherokee Nation case was figure out whether the Supreme Court had jurisdiction to hear the case, since it hadn't come to it by on appeal, and they could only do that if it was a suit between a state and a foreign nation. So the question is, are the Cherokees a foreign nation for purposes of the jurisdiction in this case? The answer to that was no.
Right.
But that doesn't necessarily mean anything beyond that. And over the succeeding years and different sort of unfortunate policy phases, I think we've tended to give that language more meaning than it really deserves.
Some people have taken it to be the sort of ward to a guardian.
Yeah. And there are legal consequences that follow from that now, but that's a relatively modern thing. I think that's a late 19th century thing. The other thing I should say, though, about, I would agree with what Ty just said, but I think in Worcester versus Georgia, he actually reverses a good portion of the Johnson decision. But even Johnson, to answer your question about the sort of what it tells us, the troubling nature of the decision, it is troubling, but in the same perverse way that so much of federal Indian policy is sort of, it's not self-contradictory, it's that it sort of cuts both ways. You've got a rule that says that tribes don't own their lands, but they do own an occupancy right, and that actually has fairly significant meaning, and it's a right that's enforceable at least against everybody who's not the United States government. So there's bad stuff, but there's sort of good stuff tossed in there, and it's a stronger and more expansive right than indigenous peoples have in their lands most other places in the world. So back to grading, it'd be really hard to grade because we don't know exactly what the scale is against which we're grading.
Lindsay, it sounds like you're arguing really for a kind of ambiguity. So I think you have a way to read it and you're probably right. People have read it other ways, and the ambiguity has allowed that.
Yeah, I think there's truth to that.
1934. This is not a Supreme Court decision, but the Indian Reorganization Act. Was that a good thing? I mean, didn't it sort of allow tribes to set up a legislature, judiciary, executive branch, et cetera?
It's recently had some criticism from folks, but I actually think the IRA was a good thing, particularly because in it, Congress expressly repudiated the allotment and assimilation policy and acknowledged that that had had devastating effects for Indian lands and Indian communities. And
Allotment assimilation policy, would you explain that?
Sure. The allotment and assimilation policy runs from either 1871 till around 1934, when the Indian Reorganization Act is passed, and although some people count it from 1887, and it had three primary aims. The first was to assimilate American Indians into the dominant culture and the dominant body politique. The second was, instead of three, I'll just say two. And the second was to break up tribal communally owned lands and allocate individual property to families, and then treat the remainder as surplus lands. And like all policies in federal Indian law, there were certainly people who supported it because they were motivated by animus, racial animus and greed and religious chauvinism. But there were also people during that time, the Boston Brahmins, for example, who described themselves as friends of the Indians, and they looked at the external pressures confronting tribes and thought, in the midst of the Industrial Revolution, the best thing we can do is interrupt the intergenerational transmission of knowledge and shift their culture and make them, in the language of the time, Christian yeoman farmers. But it did have devastating effects, and whether good intentioned or bad, it was the will of the United States being done rather than that of the native people themselves. And the IRA in 1934 repudiated that policy and said that we actually want to revitalize tribalism, and we want tribes to be economically self-sufficient so they can create their own businesses, and we want them to, we reaffirm that they have the right to create a government of their own choosing. And so, sandwiched between allotment and assimilation and between the termination era that starts after World War II, I'm a fan of the IRA. I think that it was well-intentioned and for the most part had positive effects.
Let me throw out another decision. 1974, Morton versus Mencari. My lay reading of that is, it seems like the 14th Amendment, just equal protection under the law, just doesn't apply to Native peoples. Is that right?
Well, it applies to Native peoples. It's just what Morton was a case where a couple non-Indian employees of the Albuquerque Bureau of Indian Affairs office applied for promotions, didn't get them, and the reason they alleged was that they lost them to equally qualified tribal members, and the Bureau had a tribal citizen promotional preference, and they argued that that was race discrimination. And so what the Supreme Court said was, it's not race discrimination, because what makes those people Indian isn't so much their DNA, their ancestry, as it is their citizenship in a federally recognized tribe. So that their classification as Indian wasn't a racial classification, it was a political classification. That's hugely important. And it's hard sometimes to explain that to folks in other countries where there's an identity between race and political identity. Here, you can be, you can not look Indian, as people say, and still be a full voting citizen of a tribe. The Equal Protection Clause, then, the court said, does apply. It's just that we're not as concerned about discrimination based on political classification, so we'll subject it to a lesser standard of review in order to survive equal protection challenge in legal speak.
Again, it opens up a kind of ambiguity where there could be a kind of neglect, though, right? If there isn't the same standard of review, right?
Well, I think that's a problem that exists in law everywhere. You know, sometimes the law is a tool for folks in power, and sometimes the law constrains people in power, and I think this is a good example of that, that the lower standard of judicial review allows for hiring preferences, but it also allows for diminishment of property rights in earlier cases without overruling those early decisions.
Yeah, and it's also important to remember, though, that if you're on the downside of a federal policy and you're a tribe, you may, maybe I can't bring an equal protection claim, but I can bring a breach of trust claim. Right, because the federal government has claimed the power to be my trustee, and there are certain obligations that flow from that, and that's not available to groups that aren't tribal.
Right. It seems like there's a lot of court-made law precedent that has shaped Indian policy. and not a lot of legislation. Why has the Congress not kind of led the way? Why they've left it to the courts? It seems like an awfully large burden to put on the courts.
But it sort of depends on when you are. I mean, there is a lot of legislation. I mean, there's a lot of legislation now that sort of governs the nuts and bolts stuff. So that I mean, it is true. I think maybe what partially shapes your perception is that in Indian law, almost uniquely, all of those old cases are still alive. They still get regularly cited. There aren't that many non-Indian law 1823 opinions that anybody's even heard of.
Right.
And Johnson gets regularly cited. So there's this accumulation of case law that still plays a viable role on top of whatever the modern statutes have to. So it might be maybe more of a misperception based on that.
Controversial law that I think, this is an actual law that was passed by the Congress, the reauthorization of the Violence Against Women Act was reauthorized in 2013, originally passed under Clinton in 1994. Talk to us about that.
Well, I talk about the Indian dimension of it. In 1978, the Supreme Court held in a case called Oliphant versus Suquamish Tribe that tribal courts couldn't exercise criminal jurisdiction over non-Indians. And that sort of the restriction got increased for a while and then relaxed for a while. But the rule today is that in virtually all instances, and the universal default rule is that tribal courts can't exercise criminal jurisdiction over non-Indians. That was creating a huge problem in a lot of tribal territories because non-Indians would come in and commit criminal acts, and the tribe had no jurisdiction over them. The federal government did, but they don't have the resources to prosecute every offense committed everywhere. So a lot of U.S. attorneys' offices were declining to prosecute these, and so these offenses were going unprosecuted. And a lot of them, it appeared, based on some studies that the Department of Justice did, were acts of violence against Native women committed by non-Indian men. And what Congress did in 2013 when they reauthorized the Violence Against Women Act was to include language that expanded tribal criminal jurisdiction, assuming that certain circumstances or certain elements were complied with, over non-Indians who commit acts of domestic violence against Native women. And this is revolutionary. It's one of the first. It's the first time in U.S. history when tribes have clearly had, pursuant to federal statute, criminal jurisdiction over non-Indians.
It seems like such an obvious point that this law was needed. I know there's controversy about the specific statistics, but it seems like to be a Native woman is a very dangerous position to have in this culture. I mean, much more likely to be a victim of, be a homicide victim or domestic assault or sexual assault or whatever. Why was it so difficult to reauthorize this? I remember a couple of times it's been authorized maybe 3 or 4 times now, and it was really fought and opposed by a lot of people in Congress. Why would this be so controversial?
Well, I think the statute as a whole was controversial for reasons wholly unrelated to Indian law. There were, there were questions of policy about criminalizing, private acts and about specifically targeting women for protection, I think on a national level that created discomfort. But frankly, I think no one really knew about the Native dimension and the jurisdictional void that Lindsay described. I think most Americans had no idea that Native women were sort of uniquely vulnerable as a result of the law.
Did the Native Clause only come in 2013? Was that a late edition?
That's right.
Okay.
Those were the amendments added in 2013. Yeah. And
weren't there earlier versions that I think the ACLU had some trouble with, where people that were accused of certain kinds of sexual crimes had to undergo DNA testing? They hadn't been convicted yet, something like that. And
I think so, but
I
have to admit
that's struck later.
That's not related to the Indian side, so
Right.
I have to plead ignorance on that.
Yeah. So this is a good thing.
I think undoubtedly, yes.
And we'll see how it works. Yeah, I mean, there were certain concessions that tribes who want to exercise this jurisdiction had to make, and it's not clear whether that part's a good thing. I mean, they had to change their procedures, provide attorneys and things like that, and those are things that the tribes might not have done on their own. So.
I would have to think that figuring out the outcomes of this, if people try to discover later, is this a good act or whatever, is going to be complicated, because my recollection is that in one of the reauthorizations, the bill was like $1.6 billion. It was a lot of money. And we're talking about really a lot of programs under the umbrella of the Violence Against Women Act. So it's a huge undertaking, right?
Yeah. Well, at a minimum, one of the obligations imposed on the federal government by the statute is to start keeping better statistical information on what's actually happening in Indian country.
Okay.
And that's going to be helpful. I mean, a lot of federal policy is made and avoid anecdote and guessing and that sort of thing. And so at least in this area, we're going to have hopefully some pretty reliable information.
The other area that I think of where I think Indigenous people are impacted a lot is environmental law, environmental issues. Could you help us with that?
Sure. There are a number of important issues that fall under this umbrella. Overexploitation of resources is a real problem, particularly since for many tribes, their wealth is in the form of their natural resources. Inordinate levels of pollution in Indian country is a real problem. But
why would there be inordinate levels of pollution in India? Why there?
Well, when you think about environmental justice generally, those that experience the consequences of environmental degradation tend to be politically insignificant populations. That means they tend to be poor farmers, poor inner city dwellers, and poor Native Americans. And particularly in Indian country, because of the special jurisdictional rules, we wind up having pollution take place outside control of the tribe that winds up not being cleaned up. And because it's so rural, it affects fewer people. And as a result, doesn't get prioritized on things like the national priorities list for CERCLA.
So if I'm a company and I'm going to build a factory, if I build it on tribal lands, I don't come under the same scrutiny of the federal government. The same laws I don't come under the scrutiny of those laws that have to do with pollution, right? And so I could be a little freer to pollute.
Well, no, you would be subject to federal law. You would not be subject to state law, but for the federal government, their environmental laws are intended to apply uniformly everywhere, and so they do apply, but regulatory resources may be less likely to be directed to those areas. But as a matter of legal coverage, they're covered, but as a matter of factual protection, I think they get less attention.
But you're talking about a pattern of sort of industrial waste products ending up probably closer to poor people, really as a pattern across the United States, but specifically in tribal lands.
Yeah, I think it is an inordinate problem in Indian country. Open pit mining is another problem that pollutes water resources and air resources and destroys land as well. When I think of an environmental issue that keeps me awake at night, though, it is definitely the consequences of climate change in Indian country, because tribes, whether they're in the desert Southwest, where we expect desertification to expand, in Florida or in Louisiana, where we expect water level changes to affect tribal resources and groundwater salination to be a problem, Indians are inordinately affected by climate change, and they are the least able to respond and adapt to climate change. And so we wind up
inordinately affected because they're poor, or
because they're in places that will be very affected by climate change, and because they lack resources to respond and adapt to those changes. Like poor people around the globe or indigenous groups around the globe, the people least responsible and least able to respond are the ones most affected by climate change.
And just to add to that, perhaps the indigenous communities most affected are the Alaska Native communities.
Without a doubt.
Who are losing their land, essentially, as the permafrost melts and their areas are threatened with becoming uninhabitable. The UN Committee on the Elimination of Racial Discrimination in August reviewed the compliance record of the United States with the International Convention on the Elimination of All Forms of Racial Discrimination. One of the questions that the committee asked the United States delegation was about this permafrost problem, about how the U.S. was addressing climate change so as to protect the homelands of indigenous people.
Now, there's a UN Declaration for the Rights of Indigenous People passed in 2007. Would that have any bearing on these environmental issues? Would it?
Yeah, there are environmental provisions in the UN Declaration on the Rights of Indigenous Peoples. So there would be some application. The declaration itself doesn't provide any concrete recourse, but there is language that can be cited.
It's pretty involved, isn't it? I mean, something like 43 preambular declarations and 46 articles, whatever. But it's not enforceable anywhere, is it?
Well, it's a declaration. So as a matter of international law, it's meant to be aspirational. This is textbook definition of a declaration, as opposed to a convention or a treaty, which is enforceable according to whatever the terms of the treaty or convention are. That said, there is something in international law called customary international law, which is sort of like common law, international law. And it's the international law rule that if everybody's doing something a certain way and they come to believe that they're supposed to do it this certain way, then it becomes enforceable. And there are advocates over time, and and we don't know how much time, but there are folks out there making the argument, and it's a plausible argument, that because the declaration was was supported by just about everybody in the world, or has been since, that it has the status of customary international law.
The U.S. didn't sign originally, with New Zealand, Canada, and
Australia. We have 4 no votes. Yeah, there were some abstentions too, but those were the 4 no votes, and all 4 of those have since changed their position.
Eventually changed. We've got less than a minute. Give us something that you think is really an encouraging development on the horizon for rights of Indigenous people. What would that be? Something you would focus on?
Well, I think the growing internationalization is a good thing. I think there's a lot more conversation about Indigenous rights globally, a lot more awareness globally, and more cooperation. This is something at the law school that we're very sort of attentive to. This is why we set up the International Human Rights Law Clinic, which focuses on representing within the UN system Indigenous groups from around the world. We've got international fellows coming in. We're very much a part of that international conversation.
We're going to have to stop there. I'm so sorry. Thank you guys for being with us today. I'm glad that you could be with us. Please join us next time for more current conversation. Thank you for watching.